through what exactly transpired in the court as we try and connect with our legal correspondent as well. Justice Hemant Gupta has said that there is a divergent opinion and he has framed 11 questions. So as Harish was pointing out, there are different questions that were before the court, about 11 questions that have been framed by the two judges. On these 11 questions, there are different arguments which have been made and divergent opinions that has been taken by Justice Hemant Gupta and Justice Dhulia. Let's talk you through what Justice Hemant Gupta has said. The judge who believed that these appeals should be dismissed. The judge who agreed with the order of the Karnataka High Court. Now, whether college management can take a call on uniform of students and if wearing of hijab and restricting is violative of Article 25, whether right under Article 19 and 25 are mutually exclusive, which means your religion is protected and you have a freedom to expression, and that is why you can wear what you want, and if anybody tells you anything otherwise, your fundamental rights are encroached upon. The court, Justice Gupta, is of the view that these are not the arguments that can be entertained. His argument is, his understanding, the limited portions of the judgment that have come out is that hijab is not protected under the essential religious practice of Islam. Let's come to Justice Dhulia, who has set aside the Karnataka High Court order and quashed the government order and notification. He's the dissenting judge. He doesn't agree, in a sense, with what his brother judge is saying on the bench and with the Karnataka High Court. Justice Dhulia says that venturing into the essential religious practice is not important. What needed to be done was to test it on the question of choice. There's a very interesting case of Bijoy Emmanuel. And in that case, there was a person who did not want to stand up for the national anthem. And, he said that this is something which my religion doesn't permit me to do. And the constitution should protect that right. The court went into that entire matter and said that, look, if your religion doesn't allow you and there are grounds to believe that it's an important practice for you, we will allow you to be. Those are the kind of judgments that were cited from the petitioner's side as well, as far as personal choice, liberty and your own self is concerned. I want to cut across back to Harish, who continues to be with us on the broadcast. Harish, as you were pointing out, there are 11 questions that have been framed by the court. It's very interesting to note that the petitioners in this case, who went to the Supreme Court, shifted somehow from the essential religious practices argument to an argument which is more about individual liberty and personal rights.
Whatever she wants to wear, she can wear. And the third thing which he has emphasized in this judgment is that he has emphasized on the education of the girl child. He has said how the girls in the villages and how the girls in the remote areas they work, they have to assist their families. Then they have ultimately they go to the school. So it's very important for the girl child to have her education. So he has emphasized on the education of the girl. He has emphasized on her choice, and he has depended on the Bijoy Emmanuel judgment, which has upheld this practice where a lady can put whatever covering. I appeared. One of the petitioner was Charanjit Kaur, in which she was a Sikh lady. She was saying that when I have this choice, then other girls and other ladies and other ladies from the various communities, they should have all this choice also to cover their heads while they are going to schools or wherever or which place they are going to. So my name is Aftab Ali Khan.
Thank you very much.
This ultimately has been referred to the CJI for constitution of the larger bench. आज का जजमेंट आज का जो जजमेंट था हिजाब का, बहुत दिन से जिसके ऊपर इंतजार था, वो आज जज ने कोर्ट ने प्रोनाउंस कर दिया है और इसके अंदर स्प्लिट जजमेंट आया है. इसमें ऑनरेबल जस्टिस हेमंत गुप्ता साहब ने उसको जो है अपील को जो है उन्होंने डिसमिस करा है और जियो वगैरह जो थे कर्नाटका गवर्नमेंट के उसको अपहेल्ड करा है. लेकिन जस्टिस गुलिया ऑनरेबल जस्टिस गुलिया ने डिफरेंट व्यू लिया है इसके अंदर, इस मैटर के अंदर, और उन्होंने इस मैटर के अंदर उसको अपील्स को अलाउ करा है और उन्होंने 3 पॉइंट्स के ऊपर इसको मेन एम्फेसिस दिया है. उन्होंने एक तो बिजॉय मैनुअल का जो जजमेंट है सुप्रीम कोर्ट का उस पर रेफर करा है और उसके बाद उन्होंने ये जो चॉइस है जो अपना सिर के ऊपर किसी को हिजाब रखना है या किसी को कवर करना है, ये लेडी का अपना चॉइस है, तो इस पॉइंट के ऊपर भी उन्होंने एम्फेसिस दिया है. और तीसरा पॉइंट जो इम्पोर्टेंट उन्होंने बोला है कि जो बच्चों की तालीम और एजुकेशन का मामला है वो बड़ा इंपॉर्टेंट है और बच्चों की तालीम के लिए हमें ऐसा कोई काम या ऐसी कोई चीज़ जिसमें उनकी एजुकेशन के ऊपर रुकावट आए तो उस चीज़ का उन्होंने एम्फेसिस दिया है कि ऐसा कोई काम जो है उसके खिलाफ है, बच्चे की एजुकेशन के खिलाफ है. कोर्ट ने इस मैटर को अब आगे के लिए रेफर कर दिया है, वो उसके अंदर अब लार्जर बेंच के लिए रेफर करने के लिए उन्होंने आगे भेज दिया है इसको, बिकॉज ये एक स्प्लिट जजमेंट है तो आगे डिफरेंट बेंच अब आगे इसको सुनेगी. मेरा नाम आफ्ताब अली खान।
That was one of the lawyers who was elaborating what exactly transpired in the court. I'm cutting across live to the Supreme Court of India, where my colleague Harish Upadhyay and our legal correspondent Ananya Bhatnagar are present. Harish, I'd like to know from Ananya and both you what exactly transpired in the court. As you said, we are waiting for the written copy of the order. But what is it that we so far know? What was pronounced to the court? What was said in the court?
Hello.
Well, in terms of the kind of order that's come out, at least whatever the information is coming out right now indicates that perhaps there's a direct split on most issues. There has been a differing order that's come out. One judge says, as far as I am concerned, it's a matter of choice. The other really upholds the Karnataka order, Karnataka High Court order, and doesn't really believe it's an essential religious practice. We don't know if there has been an order on whether this bench believes the High Court going into the essential religious aspect test was right or not. Ananya joins me. Ananya, a clear split verdict on most crucial issues. We've had both of them giving differing opinions.
Well, definitely it's a split verdict that is coming from Justice Hemant Gupta and Justice Sudhanshu Dhulia. A very, very crucial verdict wherein Justice Hemant Gupta actually says that he is going on to dismiss the appeals. He's dealt with all the 11 questions. We are still awaiting for the final, the detailed judgment to come in. But then at this moment of time, we have to discuss it that the judgment that has come out is a very, very split verdict. While Justice Hemant Gupta says that the appeals are dismissed, the Justice Sudhanshu Dhulia is of the opinion particularly that hijab should be allowed inside, in fact, the educational institution. He says that girl-child education is a much more important issue, and that is something that is of value. He just read the operative part of his order. We still have to wait to note the dissenting opinion into this particular case. But as soon as the judgment is out, we'll get to know what the two judges think, what is actually behind their minds as to what had happened into this particular case. But remember that the arguments that have been placed from both the sides. Remember, 11 senior advocates from the petitioners and in fact Solicitor General Tushar Mehta, Advocate General of Karnataka Prabhuling Navadgi, representing the Karnataka government from the other side, has remained almost for 10 days. In fact 11 days the matter has been heard, and a very, very crucial one. While the petitioners had argued on the actions of the ERP, whether hijab is an essential religious practice or not, whether it has been there, it's actually important or not inside educational institutions, while the government has defended all of it. Yeah, Harish.
Ananya, in fact, we are talking about the Karnataka High Court order and this observation made during the hearing here that perhaps the court shouldn't have gone into the test of essential religious practice. On that, you have Justice Dhulia saying the main thrust of my judgment is the entire concept of essential religious practice was not essential to the dispute. The High Court took a wrong path. It is ultimately a matter of choice. Article 14 and 19. Clearly, at least Justice Dhulia believing that the Karnataka High Court shouldn't have gone to this test of essential religious practice. It wasn't required. It was just an order that should have been given on the fifth order of Karnataka High Court, and taking into account Article 19. That should have been the path that the Karnataka High Court should have taken. So a split on that as well.
Well, definitely a split on that aspect, and Justice Dhulia believing that it's a choice that has to be there. And in fact, what we want to know actually from the final judgment is that why Justice Dhulia thinks it, what is the basis behind he says that it's a choice. So a very, very crucial opinion that is coming from the Karnataka High Court's, the Supreme Court's division bench of Justice Hemant Gupta and Justice Sudhanshu Dhulia. And what is very